Okay, guys, sorry you had so much music for so long, but the I'd gotten a message that I had no internet. Hey, morning, Ron. How you doing today? So I'd gotten all of a sudden I'd got unable to do something for lack of internet access. I was like, what the hell's going on? So I'm looking around to see what's going on, and uh, so I'm just trying to figure out what's going on here. Oh, well, it looks like something is not working right, and I've got to figure out what it is. Uh, okay, I'm slowly but surely getting there. I'm hoping everything works all right. Okay, I see what's going on. Ah, gotcha. All right. Okay, looks like I do have everything working, even though it's not working on my phone, which absolutely confuses the daylights out of me. But that's all right. I will just hot attach to my computer, and I will use that for my phone. Anyway, good morning, Ramen. How you doing today? And let me get all messages on my phone. There we go. Okay. So a couple of things I want to look at, and it's just changing up because of something that just come across to my attention. Let me see if okay, here we go. All right. Congress has passed the bill cutting funds to NPR and PBS. Uh-oh, what's wrong, Ramen? If you don't want to talk about it right now, we'll talk about it after the stream's over with. Because I've got nothing, no place I've got to be today. All I got on my agenda for this afternoon is baking some bread. And I can bake bread while talking to you. So, but anyway, this popped up, and my personal opinion: PBS and NPR both need to be defunded. Plain and simple. Their very obvious liberal bias is well known. And with their liberal bias being very well known, uh, and when you're getting government money like that as a news organization, you cannot afford to be biased because it's the government giving you money, and the people that you support won't always be the ones in power. So you need to play it down the middle of the road. And as a news organization, if you're going to truly be a news organization, then you need to play it down the middle of the road just as part of news ethics. So you've got two reasons to play it down the middle of the road. Not kiss anybody's butt, not kiss the ring of anybody that happens to be in power, but to be there and to tell the story that as it actually is. No ifs, no ands, no buts, no I'm leaning left, no I'm leaning right, straight down the middle, report the facts. All right. The who, the what, the where, the when. All right. Those four things. Who, what, where, when. Because when people start reporting on the why, that's where they screw up. Why did this happen? Because Republicans suck. Why did this happen? Because Democrats are fantastic. And that is what got PBS and NPR in trouble. Because they relied so much on that why that they neglected to tell the other parts of the story. Because all they wanted to do was do the why. Why? Because the people I like did it, or why? Because the people I don't like did it. And if there was anything that the people you didn't like did that was good, you just didn't report it. Or you spun it to make it seem less important than what it was. Anyway, so MSNBC had a former NPR PBS person online as an interview. And she is currently works for MSNBC. So you tell me, is that really that great of a jump to go from PBS to MSNBC? I mean, face it. If you're going to work for MSNBC, you've got a bias that's going to play very well with MSNBC.
I'm worried. I'm very worried. To be clear, the mothership, the flagship station, NPR as a national media entity will probably be okay. PBS in the mothership will probably be okay. It's the smaller.
And why would they be okay? Because they get millions of dollars in private donations. They get millions of dollars in commercial money from, every time you buy an Elmo or Big Bird or, one of these Sesame Street characters, particularly Elmo, he's the most popular one. NPR and PBS gets a cut of that money. All right. PBS is now on a streaming service, Sesame Street's now on a streaming service. So they get a cut of that money. Every time their show is watched, they get a cut of that money. So they are a commercial entity. So, they're not, PBS as a whole, NPR as a whole is not going, they're not going to suffer because they're, as a percentage, they're not losing that great of, they're losing a lot of money, but as a percentage of the money they get in, they're not losing that great of it. They're not losing 75% of their funding, nowhere near that.
Stations that serve a huge number of people that are really going to be hurt by this. It's 1,500 radio and television stations, and when you think about the services that they provide, we've just seen flash flooding across the country, in Texas, in the Carolinas, in New York and New Jersey. When they distribute the warning systems, you have to have a delivery system for that locally. And since a lot of local news organizations are now gone, it's public radio and public TV, but public radio in particular, that actually accepts that and then serves as the warning system.
Okay. Let me dispel a little bit about this, all right? If you think about it, just if you put 2 seconds thought into what she says. First of all, if PBS radio stations are going to be the deliverer of the news flash for the weather, only people that actually listen to the PBS station is going to hear it. Only the people that are listening at that particular moment are going to hear it. Now, I don't know about you, Raman, okay, or anybody else. I get weather alerts all the time on my phone. All right. I'm signed up for weather alerts to my phone. I'm signed up to other emergency alerts to my phone. I get text messages, I get phone calls. Automated. Everything's automated, but I get text messages and phone calls. My wife gets them to her phone. So, I mean, we don't need PBS or NPR. If you have a cell phone, you can get these alerts. Oh, you sign up for them. You sign up one time and it's set and forget until there's something going on. I mean, hell, even our local government, the city governments and the county government sends out text messages. This road's going to be closed. This road's going to be closed. This road's open. This business is going to be closed. Just a reminder, everybody's going to be closed on the 4th of July, and on the 1st of July, being as that's a Friday, we are going to be closing down at noon. Exactly, Raman. So, do we really need PBS? Is PBS really that great of a player when it comes to warning people about bad weather coming in? I don't want to, I can't, I mean, my phone wakes me up in the middle of the night because of a storm warning. And then a couple of minutes later, my wife's phone wakes us up because of a storm warning. So, she's really, really pumping up the importance of PBS and NPR and the PBS radio stations as being the sole warnings for people to get the news that there's bad weather coming in. I mean, I would even say that she's being a bald-faced liar here, but that's there's oh really? Okay. So yeah, there is no great need for PBS to be out there as a warning to people. Not even out in the most rural parts of the country. Because if you're getting out so far out in the country that you don't even have cell service, you don't have radio service.
If you think about the way that you listen in a big city, you hear news and traffic on the eights or something like that. What we're talking about in big swaths of America is information that's life-saving, whether or not you should go up in the mountains because of an avalanche fear, whether or not the ravine is overflowing, whether or not there is a flash.
PBS is not going to be sitting there warning you about imminent uh, rock slides. PBS isn't going to be warning you about a flash flood. PBS isn't going to be warning you about avalanches.
Flood warning, and people will not have access to that. It's clear that this administration needs to change the subject. They need.
They have been Trump. That was part of Trump's Agenda 47 to defund PBS. So that's not here to change this subject. This is a promise he made. You're right, Raman. But I don't think she's ignorant. I don't think she's uninformed. I think she's just being deceptive because she doesn't want to see her former employer, a very the liberal mouth at government expense, having their money cut.
Need an enemy, and they have long picked on PBS and NPR, and in doing
And now that's the truth. They have long picked on them because why? Because PBS and NPR were mouthpieces for the Democratic Party. And the thing is that wasn't even counted as DNC. There was no DNC contributions in kind or anything else like that done by PBS and NPR. So they got all that. Remember Trump's first election? CNN held that meeting, and the head of CNN at the time, I think his name began with a Z. I don't remember exactly what his name was. He said, we gave Trump too much free airtime. We gave him too much airtime to express his views. That's why he got elected. Remember they said that? Because they carried his speeches, they carried his town halls so that people knew what he was talking about. And because of that, he got elected because they gave him too much free airtime. They've never had a problem with carrying Democratic leaders. They never said, well, so and so got elected because, Democrat so and so got elected because we gave him too much airtime. Oh, no, no, no. We had to give them that airtime so that we could have an informed public, so they could have an informed vote. But Donald Trump gets elected. Oh, no, we gave him too much free airtime. People got informed on what his positions were. Hey, morning, Data. So, and NPR, man, they love their Democrats. So I've got decades ago, NPR should have been defunded out of the government.
in going after these stations, they're willing to do this, even though they know because people have been calling their members of Congress and they've been calling the White House. They know what PBS and NPR means to their constituents. They don't care. They're willing to score a political victory, even if it means snatching something important from the constituents that they claim to care about.
And the constituents that have been calling have mostly been Democrats. How dare you cut off funding to my favorite liberal station? How dare you cut off funding to my echo chamber? How dare you do that? I tell you what, I'm all here for it. I really and truly am. I'm here for it. I love it. Okay. The fallout from the piss poor Diddy prosecution is happening. Now, Diddy got convicted of the most minor charges. He's not going to spend much time in jail. The racketeering, the drug dealing, all that stuff, he got off on that. They'll still be around. They will still be around. NPR gets okay, let's see here. Uh hmm, NPR funding sources breakdown. Here we go. All right, here we go. NPR's percentage of unrestricted revenue category, FY 2009 through 2011. Sponsorships, 24%. Station programming fees, 37%. NPR Foundation support, 4%. NPR Foundation endowment, 6%. Investment, 1%. Distribution services, 12%. Other revenues, 6%. Membership dues, 2%. Okay. Let's see here. Let's see if we find one that shows government. Okay, come back here. Oh, okay, I'm trying to find this here. Corporate financial board returns programming other and satellite distribution. Grants. Okay. Ah. Let's see if this tells me. And There, I cannot real quick here find. Uh, okay, it's less than 1% of their total budget. All right, NPR claims it receives minimal. Okay, here we go. I'll share that. All right, this here is from News I8, whoever that is. Okay, and although NPR claims it receives minimal direct federal funding, less than 1% of its total budget, much of its financial support flows in directly from member stations that benefit from CBP grants. The allocate substantial under Public Broadcasting Act 67, directing resources to local public media stations often use these funds to pay for NPR programming. There we go. So, oh, well, Data, please tell me you had their insurance and not your insurance. And that, of course, that you're okay. But please tell me you were using their insurance, that you paid that extra $50 or whatever to use their insurance and not your own private insurance. Oh, yeah, Ramen. Yeah, local PBS stations here do the same thing. Anyway, all right, that's wonderful data. That's never, even though it might save you $50 or so, always use their insurance. Don't use yours when you rent a car. That way, your insurance isn't the one taking the hit and your rate's going up. Okay, Maureen Comey, federal prosecutor in Sean Diddy Combs and Ghislaine Maxwell case, is fired. And Maureen Comey is the daughter of former FBI Director Comey. So that probably didn't help cement her position within the Department of Justice, being related to that idiot. All right. However, I think what's absolutely, and again, my own personal opinion here, Maureen Comey was fired because of the piss poor. She didn't get convictions on Sean Combs, not on the RICO statutes. She did not get him on the big charges. She got him on the piddly ass charges. What almost would have been throwaway. Hey, Digi, glad to see you, even if you are just stopping in for a moment. But she got fired yesterday afternoon. I'm sure she's got a nice golden parachute or something, so she's okay. She's not going to be hurting, and there'll be plenty of law firms that will jump in to take her. I mean, she loves being a prosecutor. You know, New York City or New York State would love to have her. So, I mean, being her between her name and coming out of the Justice Department, yeah. So, and of course, Justice Department is not saying why. They're going to say it's a personnel matter, and they're not free to discuss that kind of a personnel matter. So, but the left is going to make big hay out of her being fired yesterday. So just go ahead and bring that up. And the man we all love to hate, and the man that if you don't love him, I don't know what's wrong with you. Jelly Roll choke slams Logan Paul through the desk on the Jimmy Kimmel Live. And at first, when I first read that title, I was like, "Oh my God, what did Logan Paul say to Jelly Roll to piss him off?" Jelly Jelly Roll, for being a big guy, is really mellow. Well, what it is it was all a stunt because Jelly Roll is going to be part of some WWF or WWE event here soon. So you're going to be part of SummerSlam. So I have been to a I'm trying to remember if it was WWE or WWF at the time. I was back in, I went to a wrestling expedition while in Las Vegas, TDY for the Air Force years ago, back in the 90s. And I went and saw Hulk Hogan. Well, I mean, we was in the nosebleed section. I mean, they looked like little dolls down there jumping around. We were so far up. But yeah, I got to watch Hulk Hogan, Andre the Giant, and a couple other big. The only two I really remember is Hulk Hogan and Andre the Giant. And well, we were pissed off at the pilots, so we didn't go to their little shindig they were throwing. We went to this wrestling match instead. Instead of going to get free hot dogs, we went and got paid money to watch wrestling. So, but yeah, if you're a WWE fan and you want to watch Jelly Roll get into the ring and probably going to go up against Logan Paul in the ring, just go ahead and watch SummerSlam. And if you don't know who Jelly Roll is, I feel sorry for you. You have my deepest sympathy. And let's see here. I'm slowly but surely getting to the stuff I've got on my thumbnail for today. In fact, that's where we're going now. I mean, you know, those just a couple of things that popped up this morning that is like, ooh, this is interesting. So, okay. Let's see here. If I do that, I'll do that last because I don't like them people. And we'll come over here to this, and I can close that tab. Yay, man, I'm closing tabs left and right. Joe Biden's work husband, if that isn't something to be proud of being called, refuses to answer oversight questions. Former First Lady Jill Biden's chief of staff refused to answer questions during closed-door testimony before the House Oversight and Government Reform Committee. If you'll remember the other day, we had the doctor, and he refused to answer questions. Well, now, so let's come on over here and watch this.
Pursuant to House Rule 10. Accordingly, House Rule 10 grants the committee broad jurisdiction for the committee to conduct investigations of any matter at any time. The committee noticed today's deposition on July 11th, 2025. I will mark the notice for this deposition as Exhibit 1.
Yay! That man, I just love these openings to these hearings. Now, this is closed door, but they got us out on video with it.
Can the witness please state his name and spell his last name for the record?
Anthony Bernal, Bernal.
Thank you. My name is Jake Greenberg, and I am the Chief Counsel for Investigations for Chairman James Comer. Under the Committee on Oversight and Government Reform's rules, you are allowed to have counsel present to advise you during this deposition. Do you have counsel representing you in a personal capacity present with you today? Will counsel please identify themselves for the record?
Jonathan Sue on behalf of Mr. Bernal.
Margaret Hines.
Thank you. For the record, starting with the majority staff, can the additional staff members please introduce themselves with their name, title, and affiliation?
Margaret Harker, Senior Advisor for the majority.
Mitch Benzine, General Counsel for the majority.
Raman, I used to have a work wife, but she quit working, so I don't have a work wife anymore.
Billy Grant, Counsel for the majority. Peter Spector, Professional Staff Member for the majority.
Melvin Soto, the Legal Director for the majority.
In the minority?
And once again,
Thank
this
you
is
all.
the
And
thing here.
members in the room,
Minority,
will you identify yourselves, please?
redacts their names. They don't want us to know who's out there
Pete
defending the
Sessions,
Democrats.
Chairman, Government Operations and Federal Workforce.
Thank you all. In this Congress, Chairman Comer initially requested a voluntary interview of Mr. Bernal on May 22nd, 2025, as part of the committee's investigation into President Biden's alleged mental and physical decline, the Biden White House's efforts to hide that from the American people, and any unauthorized executive actions. The committee is considering legislative solutions to address these issues, including exercising its authority under the 25th Amendment to the Constitution. I will enter the initial request by Chairman Comer as Exhibit 2. On June 6th, 2025, counsel for Mr. Bernal confirmed with the Oversight Committee that Mr. Bernal would sit for a transcribed interview on June 26th. On June 25th, counsel for Mr. Bernal informed the committee Mr. Bernal would not attend the transcribed interview scheduled for the next day. On June 26th, Chairman Comer issued a subpoena for Mr. Bernal to appear for this deposition. I will mark both the subpoena and the accompanying cover letter to Mr. Bernal as Exhibit 3.
Yeah, you don't show up voluntarily, they suspend you or subpoena you, and you've got to show up.
Mr. Bernal, before we begin, I would like to go over the ground rules for this deposition. The questioning will proceed in rounds. The majority will ask questions for an hour, and then the minority will have an opportunity to ask questions for an hour if they choose. To the extent members have questions for the witness, they will be propounded during their side's respective rounds. Do you understand?
I'm sorry, guys, I can't speed this up any.
The clock will stop if you need to confer with counsel. Your counsel is speaking, and when members or staff are speaking during the opposing side's round of questions. We will alternate back and forth until there are no more questions. Do you understand?
Yes.
There's a court reporter taking down everything I say and everything you say to make a written record of the interview. For the record to be clear, please wait until the staffer questioning you finishes each question before you begin your answer, and the staffer will wait until you finish your response before proceeding to the next question. Further, to ensure the court reporter can properly record this deposition, please speak clearly, concisely, and slowly. Also, the court reporter cannot record nonverbal answers such as nodding or shaking your head, so it is important that you answer each question with an audible verbal answer. Do you understand?
Yes.
Exhibits may be entered into the record. Majority exhibits will be identified numerically. Minority exhibits will be identified alphabetically. Do you understand?
Yes.
We want you to answer our questions in the most complete and truthful manner possible, so we will take our time. If you have any questions or do not fully understand the question, please let us know, and we will attempt to clarify, add context to, or rephrase our questions. Do you understand?
Yes.
If we ask about specific conversations or events in the past and you are unable to recall the exact words or details, you should testify to the substance of those conversations or events to the best of your recollection. If you recall only a part of a conversation or event, you should give us your best recollection of those events or parts of conversations that you do recall. Do you understand?
Yes.
You are required by law to answer questions from Congress truthfully. This also applies to questions posed by congressional staff in this deposition. Do you understand?
Yes.
If at any time you knowingly make false statements, you could be subject to criminal prosecution, including but not limited to perjury. Do you understand?
Yes.
This includes both knowingly providing false testimony, but also stating that you do not recall or remember something when in fact you do. Do you understand?
Yes.
Furthermore, you cannot tell half-truths or exclude information necessary to make statements accurate. You are required to provide all information that would make your response truthful. A deliberate failure to disclose information can constitute a false statement. Do you understand?
Yes.
You know, I've always been curious how they can prove that you remember something. All right. I mean, I can't remember. There are days I can't remember what happened the previous day. And my wife will stand there and tell me that I did something. I'll just look at her like, are you serious? I did that? Because I honestly don't remember. So, you know, unless he goes out bragging about it and then you get somebody drops a dime on him that he was bragging about, you know, saying he didn't remember something when he did. I'm kind of curious how they can ever get you on falsely not remembering something.
Is there any reason you were unable to provide truthful testimony in today's interview?
No.
Please note that if you wish to assert a privilege over any statement today, that assertion must comply with the rules of the Committee on Oversight and Government Reform. Pursuant to that, Committee Rule 16C1 states for the chair to consider assertions of privilege over testimony or statements, witnesses or entities must clearly state the specific privilege being asserted and the reason for the assertion on or before the scheduled date of testimony or appearance. I will enter it as Exhibit 4, a letter dated June 24th, 2025, to your counsel from Gary Lakowski, Deputy Counsel to President Trump, informing you that President Trump has determined not to assert executive privilege over issues regarding your assessment of former President Biden's fitness for the office of the president and your knowledge of who exercised executive powers during his administration. Additionally, President Trump has determined that he will not assert immunity to preclude you from testifying before the committee.
Now, you know this guy being Joe Biden's chief aide. You know he knows exactly who was doing what. He knows when Joe Biden, I mean, because we already know Joe Biden was in there leading cabinet meetings. That actually made the news that Joe Biden led cabinet meetings. Which I commented then, I didn't know that was possible for the first lady, for the spouse of the president, to have a position of authority to lead a cabinet meeting. Well, I'm watching the playback of this. I'm watching this on my cell phone, and it is jerky as hell on my cell phone. It not very smooth at all.
For the purposes of the deposition, objections must be stated concisely and in a non-argumentative and non-suggestive manner. If the witness refuses to answer a question to preserve a privilege, the committee may seek a ruling from the chair. If the committee overrules any such objection, the witness shall be ordered to answer. If the witness continues to refuse to answer a question despite being ordered to do so, the witness may be subject to sanction. Do you understand?
Yes.
Ordinarily, we take a 5-minute break at the end of each hour of questioning, but if you need a longer break or a break before that, please let us know and we will be happy to accommodate. However, to the extent that there is a pending question, we would ask that you finish answering the question before we take a break. Do you understand?
Yes.
Finally, I will note for everyone here today that the contents of what we discuss in the deposition today is confidential under the House deposition regulations. Under the rules, the chairman and ranking minority member shall consult before any release of testimony or transcripts, including portions thereof. This means it is a violation of House and committee rules to disclose content of the deposition prior to its official release. For this reason, the marked exhibits that we will use today will remain with the court reporter so they can go into the official transcript, and any copies of those exhibits will be kept at the table or returned to us when we wrap up. you have any questions before we begin?
No. Jake, I have a question. Are we afforded the opportunity to make an opening statement?
No, not today. Can the reporter please swear in the witness?
Sure. Sir, would you please raise your right hand to be sworn? Do you solemnly declare and affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, my clock reads 10:10.
Okay, 9 minutes and 13 seconds of this 19-minute and 26-second hearing was taken up just in the preliminaries. Now, the reason why I played back these preliminaries here is, I don't want accused of, editing out things or something like that. This is the hearing from start to finish. Now, when we're doing judicial nominees and that kind of stuff, I'm going to knock out all the bull crap at the beginning because it's usually ranked partisanship when I'm wanting to get to the actual questions. And I honestly, I don't care about the nominee's family. Oh gee whiz, I don't want to hear about their wonderful spouse and their fantastic children and the parents that raised them and gave them inspiration, yada 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 yada. I couldn't care less about that. So anyway, let's enjoy this last 10 minutes here of it's not even going to be 10 minutes long, I'll guarantee that.
The majority's hour will begin now. Mr. Bernal, did you ever advise President Joe Biden to pardon his son, Hunter Biden?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Well, we've heard that song before.
Thank you. We're going to go off the record real quick. Okay, we'll go back on the record. Mr. Bernal, was President Joe Biden fit to exercise the duties of the president?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Let the record reflect that Mr. Bernal has invoked the Fifth Amendment right against self-incrimination. Mr. Bernal, please be very clear. Are you declining to answer the question put to you solely on the ground that you believe the answer will incriminate you?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Mr. Bernal, did any unelected official or family member of President Joe Biden execute the duties of the presidency?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Let the record.
Now, see, this bothers me here that he's able to declare the fifth there. Because the question was about family members, not about him, about family members. So unless he's a family member, he's just refusing to answer the question. Unless it comes back that he conspired with the family members. Which is the way this looks like, is that, that he conspired. I mean, that is, it's not a legal thing that you can do. I mean, you can't make a legal determination based on that. But I can sit here and say, yeah, the reason why he's not answering that question is because he conspired with Jill. Or Jill conspired with him. So I don't know, as an aide, I don't think he was sworn in. Now, he did swear to tell the truth, but the way that question was posed, that he could say that he was, that he's protecting himself from self-incrimination, is if it can be proved that he was part of a conspiracy with the Bidens, Jill and Hunter and other people to keep Joe's mental decline a secret. But that's just my opinion on it for what it's worth.
Reflect that Mr. Bernal has invoked the Fifth Amendment right against self-incrimination. Mr. Bernal, please be very clear. Are you declining to answer the question put to you solely on the ground that you believe the answer will incriminate you?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Mr. Bernal, did President Joe Biden ever instruct you to lie regarding his health at any time, including but not limited in your testimony to Congress today?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Let the record reflect that Mr. Bernal has invoked the Fifth Amendment right against self-incrimination. Mr. Bernal, please be very clear. Are you declining to answer the question put to you solely on the ground that you believe the answer will incriminate you?
On the advice of counsel, I respectfully decline to answer the question pursuant to my Fifth Amendment rights under the Constitution.
Yeah, Raman, he doesn't want to be found as a shot in the back of the head as suicide here. He doesn't want that.
Mr. Bernal, is it your intention to decline to answer all questions put to you today by the committee on the basis of the Fifth Amendment right against self-incrimination?
I can represent that is his intention.
Thank you. Does the minority wish to ask questions?
Yes, we do.
And the lawyer answered for him so that he didn't have to answer. That's why the lawyer answered, so that he wouldn't have to. Because the only thing he's allowed to say is, I declined to answer based upon the Fifth Amendment rights. That's the only thing he's allowed to say here.
Go off the record.
Back on the record, would the members who just came into the room identify themselves, starting with Mr. Donald?
Myron Donalds, member of Congress, Florida's 19th district.
And Jasmine Crockett, Texas 30.
Mr. Bernal, good morning. Mr. Sue, you weren't afforded the opportunity to make a statement by the majority. Would you like to make that statement now?
Yes, thanks very much. Chairman Comer, Ranking Member Garcia, and members of the House Committee on Oversight and Accountability.
You notice that the minority, their questions were all redacted. Anything dealing with the Democrats has been redacted here. I wonder why. I wonder why the Democrats were afraid to let their questions get out there, or their comments to be out there.
Mr. Bernal appears before you today fulfilling his obligations to the committee. An Arizona native, Mr. Bernal has served with distinction in 3 presidential administrations, most recently as Assistant to the President and Chief of Staff to the First Lady. Mr. Bernal is rightfully proud of his service to the nation. The committee has sought testimony from Mr. Bernal for nearly 2 years without any actual evidence of wrongdoing by Mr. Bernal. Most recently, the committee seeks Mr.
It doesn't have to be wrongdoing by Bernal, but whether or not he has knowledge of wrongdoing by other people. That is the question. Does he know of other people's wrongdoing, including hiding Joe Biden's mental decline from the nation?
Mr. Bernal's testimony based on a purported controversy regarding the use of the auto pen at the conclusion of President Biden's term. President Biden has already confirmed that he personally made all decisions concerning his grants of clemency. While the committee only recently began its auto pen investigation, the chairman has already declared that this matter is, quote, the biggest scandal in Oval Office history, end quote. In addition, on June 4th, 2025,
Yeah, well, don't forget here, the Democrats, called Donald Trump an existential threat to democracy and the biggest threat this country's ever heard. And that January 6th was bigger than Pearl Harbor and 9/11 combined. So, yeah, pot calling the kettle black here when it comes to hyperbole.
The U.S. Supreme Court explained that one of the Fifth Amendment's, quote, basic functions is to protect innocent men who otherwise might be ensnared by ambiguous circumstances, end quote. The record is also clear that persons of the full range of the political spectrum in recent and historical congressional investigations have invoked their Fifth Amendment rights to decline to answer questions from Congress. Any suggestion that such an invocation is itself evidence of wrongdoing would be highly irresponsible and flatly wrong, particularly from those elected to represent the people and uphold the Constitution. For these reasons, Mr. Bernal respectfully declines to answer any of the committee's questions today in today's deposition, and thank you for the opportunity to provide the statement.
I'm entering as Exhibit A an April 1st, 2025 New York Times article titled "Trump Allied Prosecutor Looks to Undermine Biden Pardons," which describes a Justice Department investigation that, quote, uses the levers of federal law enforcement to try to harass Mr. Biden's family and allies and undermine his decisions as president while scoring political points with President Trump, end quote. I'm also going to mark as Exhibit B a May 13th, 2025 ABC News article.
This must be a second lawyer talk.
Trump's DOJ pardon attorney says he'll review Biden's outgoing pardons, which quotes Mr. Biden as saying that if the targets of his investigation, quote, can be charged, we'll charge them. But if they can't be charged, we will name them, and we will name them, end quote. Yep.
Okay, that's enough. The last 4 minutes. I didn't watch past this, to be
I'm
honest.
also going to enter as Exhibit C a May 20th, 2025 Truth Social post by President Trump, in which President Trump describes the use of the auto pen during the Biden administration as, quote, treason at the highest level, end quote, and writes that, quote, something very severe should happen to these treasonous thugs, end quote.
Yeah, well, like you said, people declare, Democrats declared Trump to be an existential threat to democracy. So, and we all know Trump was given to hyperbole and to a lot of. So anyway, there's that. I am declaring the Fifth Amendment. I am not going to answer any of your questions. I'm going to let my lawyers talk for me. And all they're going to do is sit here and say, yeah, well, Republicans do it too. So. Well, hey, Raman, did you see the, let's see here if I can find this spaghetti string again. Let's see here. And here we go. Open image, a new tab. Where'd it go? There it is. Oh, that's not the one I wanted. Or, okay. Oh, they updated this since yesterday. So you are pretty safe. Oh, I can't let my sister see these. I need to let the wife see him, though. We may be in trouble up here. Next week, we may be in trouble. Tropical Storm Dexter. It was supposed to go way south, but now they're saying it's going to come up here across the panhandle. And if it keeps shifting north, I may be getting quite a bit of rain. Well, no, see, initially Tropical Storm Dexter is supposed to come across the middle of the state. But now they got it coming up north. So you're going to get totally avoided. Yeah, I love looking at these spaghetti maps because I find them more informative than this is the danger zone. I find these more informative, but man, look at this spaghetti tree. And yes, I know spaghetti tree used to be a restaurant back in the 70s. So, well, anywho, we could be into some trouble. And I'm not looking forward to it. And okay. So anyhow, so let's get to the last part here. The last thing, the rest of the judicial nominee hearing from that we were listening to on Tuesday that I didn't finish up. Okay, and this is right where we stopped, right after Klobuchar's questioning. So let's get to the next Democrat. There we go. Now,
hey, this is Senator John Ossoff in Georgia. Not sure if you saw, but a Republican congressman who called
send you to prison, all without the assent of either house of Congress, much less both, and without presentment to the president. This is wrong. And this is why you and others who have litigated some of these issues are right to point out the problem with so-called independent agencies. They lack, under the Constitution, any proper role in the lawmaking process that bypasses Article 1, Section 7. Thank you.
Senator Coons.
Thank you very much. Ms. Hermendorfer, thank you for your service in the Tennessee Attorney General's office, and congratulations to you and your family for your nomination. As you may know, I am not a reflexive no vote on nominees of a president of the other party. I've supported President Trump's judicial nominees in his first term when they had the qualifications and experience for the job and the character and the independence to carry out the role of a judge, particularly a circuit judge, with integrity. I am concerned about the striking brevity of your professional record. You graduated from law school just a decade ago, and you spent 4 years with impressive clerkship.
Hey, Kuntz, how about Brown's appointment to the Supreme Court? Were you as concerned about her brevity on this, on the judicial brevity sitting on the courts? Because if I remember correctly, you voted for her to go to the Supreme Court because every Democrat did.
But often nominees for a position such as the circuit have real experience in court. Have you ever served as the sole or chief counsel in any case tried to a jury verdict?
Not to a jury verdict, Senator.
Have you ever served as the sole or chief counsel in any case tried to a final judgment?
I've served as chief counsel in many final judgment cases in trial court. If you mean a bench trial, I'm sorry, I don't understand. A bench trial would be no, but final judgment, yes.
How many direct examinations have you personally taken in federal court?
As an appellate lawyer, I don't usually take direct examinations, and the answer is 0.
How many cross-examinations have you taken in federal court?
None.
How many depositions have you taken?
Again, as an appellate lawyer, that's not really part of my practice.
How many depositions have you defended?
I have not defended depositions.
How many federal appellate oral arguments have you presented?
Federal appellate oral arguments, that would be 4.
And how many Supreme Court oral arguments have you presented?
None, though I've second chaired and been counsel of record in Supreme Court matters.
I'll just point out that the jurist you've been nominated to replace, Judge Jane Straunch, had 31 years of legal experience under her belt when nominated to this position in the Sixth Circuit. And the ABA, although disregarded by some, has long had a standard that without more than a dozen years of federal service, they would deem someone unqualified for positions such as what you've been nominated for. Let me move to a different issue. The Federal Rule of Civil Procedure number 65 sets out the rules of the road for issuing TROs and PIs, including whether a party moving must post a security bond. What factors should an appellate judge consider when ruling on a challenge to a security bond set or not set by a district court under FRCP 65C before issuing a TRO or a PI?
So this comes up sometimes when the state is a litigant, and oftentimes parties can move to waive the security bond. And what a court is looking to is the gravity of harm to the potential appellant should the disposition in the district court be allowed to move forward. So it's similar to kind of equitable considerations of harm and the gravity of that harm, and whether it would be reparable or compensable on the other end.
And in fact,
well, at least this was an honest question. This wasn't a biased question. This is an honest question to find out her knowledge. And she had the knowledge base for it. Okay, good there.
thank you. And in what sorts of cases is it typical to set or require a security bond?
So I think cases in which there's going to be financial exposure, for example, on behalf of an appellant, could be such a case where a bond might be posted.
Contract case or a case involving infringement of a patent or something like that. Does your analysis change if the matter is a constitutional case brought by a private plaintiff against allegedly unconstitutional actions of the federal government?
So it's, I would have to take each constitutional violation and ruling on its own terms and wouldn't want to prejudge, but the equitable factors, of course, would be the ones that I would apply in such a situation.
How would you set a bond for something as foundational as a violation of the Constitution?
I'm not sure I could answer that in the abstract, Senator.
And I'm not sure district court judges could answer that either. What tools does the Sixth Circuit or any circuit have to enforce its judgments if you were confirmed and a party disobeys an order of the Sixth Circuit, perhaps even one you wrote? What would you do?
Well,
modern look, thick, absorbent layers. But these napkins aren't just elegant, they're surprisingly affordable.
Okay.
I know that there are mechanisms by which, of course, judgments are entered and executed and enforced through federal district courts.
And what are those mechanisms?
Well, the federal district court sometimes can issue contempt rulings, for example, that are appealable. And, if you're talking about warrants or orders of those sort, I know the U.S. Marshal's Office has some sort of involvement in that, but I confess this hasn't been part of something that I've litigated.
And when would you feel you'd met the standard to call in the marshals to execute your judgment?
I think it's very difficult, again, to answer that question in the abstract.
Okay, I'm pausing this because Raman, what the hell article did you just send me? Okay, mysterious new life form discovered in black goo attached to ship on Lake Erie. Scientists have found themselves baffled. Yeah, okay. Baffled by a goo-like substance discovered on a ship dock in Cleveland, the ship research vessel named the Blue Heron is used to conduct research in oceans. All right, so let's go on down here because the first thing I thought, of course, was venom. But here's pictures of it, and that is some strange black goo. Okay. But come down here, the ship's goo's organisms appear to be part of a complex food web, possibly even contributing to biocorrosion of the metal rudder shaft. While the particular species ship goo 0001 or 001, 007, or 001 is new to the science. Some of its companions have been found in tar pits and petroleum wells around the world, suggesting these microbes may be more widespread than thought. The discovery raises interesting questions like where did the organisms originate? The lake water surrounding the vessel are oxygenated, yet these microbes can only survive without oxygen. Sheik speculates they may be dormant in the oil used to grease the rudder, waiting until conditions were right for growth. In fact, the no oozing was observed during the vessel's previous maintenance in November of 2021. That's another layer of mystery. That is something else. Does it eat oil? Does it breathe in metal like iron? Thinking about how these organisms are surviving or just thriving. Wow. Okay, that's the end of the article. Oh. That is so weird. That is beyond weird. Okay, so let's go to the next one here.
Circuits have you argued or litigated in front of?
I've argued in front of 9 circuits in the Supreme Court. Or
Nine
not argued,
circuits
litigated.
Litigated 9 circuits in the Supreme Court, over 100 appellate cases. That sounds like quite a bit of experience to me. Senator Moody.
Thank you, Senator Hawley, and thank you for running such an efficient hearing today as our chairperson. Appreciate your prior service to your state.
Performing on the biggest stage in the world was just one step in my journey. Hi, I'm Ronnie. When I teach people,
Ultimately, I believe to this country. Thank you for being here today and standing willing to answer some really tough questions.
Okay.
I will note there's been a lot of attention brought to the ABA and whether or not every senator on the Judiciary Committee, or every senator for that matter who will have an ultimate vote, considers or should consider any recommendations. And, you know, if that were important to the ABA, over the many years that people have been pointing out, they are becoming and perceived more and more and more as a partisan group. You would think they would stop doing things like awarding a progressive prosecutor who ultimately said that they would not prosecute laws that they didn't agree
From courts, efficiency of the docket goes to the heart of the fairness.
I thought I'd gotten past that.
Thank you. Thank you very much,
There we go.
Mr. Chairman. You know, you're hearing what is a real divide in the country and between the parties about what's happening in the justice system. I happen to think the ABA is an excellent organization. I'm disappointed the president is prohibiting the ABA from being involved.
No, the president is not prohibiting. That's a lie. The ABA can send all the letters they want. Anybody else can, and file an amicus brief. The president just is not going to take their word as to whether or not somebody is qualified to be an appellate judge or to be a district judge. That's all. And that's because of the ABA's past history. You know, as a typical Democrat, you are misrepresenting the truth. Oh,
There's what's happened in the Justice Department, but one of the elements from the executive branch, the judges who make decisions that the executive to some judges said who decided that is sick. There's a reference to.
Well, yeah, when judges start ruling that illegal immigrants can stay in the country, when judges start putting out nationwide injunctions well beyond the scope of their office, when judges start, allowing their partisanship to play through instead of looking at the law, then yeah, they are haters. And when they're ruling against Trump simply because it's Trump, yeah.
By the president, judges who are, quote, monsters who want our country to go to hell. I don't think that's helpful. And
it might not be helpful, but it's the truth. It may not be helpful to your side, but it's the truth about the judge. Let me rephrase that.
Let me ask you, you've had judges rule in your favor. You've had judges rule against you. Is it your view that?
But the judges that ruled against her probably weren't ruling strictly because they didn't like her or because they didn't like her politics like they do against Trump.
In your experience, when judges have ruled against you, it's anything other than the exercise of their responsibility to decide the case as they see it, or is it motivated by some political ideology?
Well, I think your question touches on foundational aspects of our system, which is obviously we're a country that values political dialogue very much. At the same time, there no doubt are limits on violence, limits on criminal threats, things like that. So, I don't want anything I say here as a nominee to be seen as
No, I'm
passing
asking,
judgment.
you've been a litigant. So you had cases decided, I take it, for you and against you in both cases.
I file an appeal and
Right.
litigate the appeal. And I will say, I mean, I've been an official, public official subject to criticism, and all I can do your duties.
Right. Do you think it's proper for litigants to be using that kind of?
Well, again, as an
It's the First Amendment right to use whatever language you want. The Supreme Court has made that ruling. Raman, are you saying that she I don't see it as that. I see her, the smile on her face being, my God, what kind of ignorant ass question are you asking me now? This says, you're sit as a judge. Okay, yeah, you're right. The other one.
nominee, I don't want to give a thumbs up or thumbs down to any particular category of statements.
All right. Well, let me ask you this. I know you signed a letter, I think you in support of the Attorney General. And in that letter, there was a reference to, quote, a dark chapter of the United States Justice Department. What specifically were you referring to when you signed the letter that had that phrase in it?
So that letter was on behalf of female members of the State Attorney General's offices.
I'm here at Shams Camp in Deir el-Balah, one of the many camps where we are responding to devastating.
I could just tell you.
I'm asking, I know who it was on behalf of, but what the letter specifically said, you're referring to a dark chapter of the United States Justice Department. So explain what that dark chapter was and what specifically you had in mind.
Oh,
So I
yeah.
spent the past 2 years litigating against rules, including Title IX and others that we did not feel as an office and as my client reflected the proper meaning of the law, and indeed dismissed many well-meaning, deeply held concerns on the part of many women and others. And so where I was coming from in signing that letter was, in my experience, litigating and often prevailing in those issues that we thought involved federal overreach by the Department of Justice.
Here's the issue for me that I think is.
Yeah, when these judges are ruling that men can be in women's sports, that is overreach. That is violating Title IX. That is a dark day in justice.
It's getting so difficult in the courts. You can have different points. Citizens can have different points of view, and they don't have to attribute that difference to something radical anti-woman agenda, or referring to the Justice Department as a dark chapter in the United States Justice Department, because this is a big country. People have different points of view. Everyone's free to advocate what it is they want to advocate for. But now it is custom that if the decision goes against you, you have a president who starts talking about monsters who want to take our country to go to hell.
all of a sudden, they're concerned about elected officials making statements like that when I don't remember him stepping up and calling out Democrats for statements that they've made. I don't remember him stepping up against when Nancy Pelosi or Jasmine Crockett or, Jenna Powell or any member of the squad. How about the things that Kamala said about Trump? I don't remember you stepping up and saying these things. I don't remember you stepping up and saying anything when they said these things about Republicans in general. Where was this big tent where people can have differing views? Where was your position on that a year ago? But all of a sudden now you expect Republicans and conservatives to abide by something that you've never demanded of your own party?
I guess I can't ask you to answer that, but you're going to be, assuming you're confirmed, in a responsibility, you're going to have the responsibility for really helping create a culture within the judicial system that hopefully restores respect. And that means respect for people with whom one disagrees. Thank you. I yield back.
Ms. Herman-Dorfman, let me just stay with this question about the Title IX litigation that Senator Welch was just asking you about. Tell us about the Title IX litigation that you carried on behalf of the state of Tennessee.
Sure. In April of 2024, the Department of Education issued a final rule interpreting Title IX, which of course bars discrimination on the basis of sex in any federally funded educational program, interpreting that language to bar discrimination on the basis of gender identity and other, quote, sex-based characteristics. And as part of that rule, which again was a rule, did not go through Congress, the Department of Education informed all federally funded educational institutions from pre-K through college that sex-separated spaces like locker rooms and bathrooms must instead be assigned by gender identity and not sex. And in similar ways, sex-separated programs like intramural sports and others fell in the ambit of that rule.
Let me just stop you right there. I want to make sure we understand the significance of this. What you're saying is that the Biden administration used an administrative process to interpret a law, a landmark law passed by Congress, Title IX, to interpret it, to require your state, and indeed every state, to allow men, biological men, into women's locker rooms, to allow men, biological men, into women's sports, to allow men, biological men, into any space that a biological woman might otherwise claim under the ambit of Title IX. Is that correct?
That's correct.
At 104 years old, Gozai Shinzato puts 70-year-olds to shame every morning.
And so you litigated on behalf of your state to preserve. Would you say that Title IX is a landmark piece of legislation?
Absolutely.
Would you say that Title IX took years, indeed decades, to achieve?
That's correct.
Would you say that Title IX?
All right, get past
political change, and it's
Okay,
not
now
up to the
let's get to
government to
shit for
stifle any
shipless.
views that it deems, heterodox or unorthodox. It is to protect the will of the people as they express it in their
Thank
public
you,
pronouncements.
Professor. Senator Schiff.
Thank you, Mr. Chairman. Ms. Herfendorfer, welcome. I'm sure aware that it was recently said by President Trump, quote, "It was suggested that I use the Federalist Society as a recommending source on judges. I did so, but then realized that they were under the thumb of a real sleazebag named Leonard Leo, a bad person who, in his own way, probably hates America." I want to ask you about this. You're a member of the Federalist Society, correct?
That's correct.
And for how long? For how many years?
Why it was recommended or whether the Federalist Society had any role.
The Federalist Society does, though, recommend judges to the administration, do they not, or did they not?
I had no involvement in that. I'm not sure. I've seen reporting to suggest they had some involvement, but I have no personal knowledge of that, Senator.
Do you think, having been a member of the Federalist Society for over a decade, that they're under the thumb of a real sleazebag named Leonard Leo? Is that your view?
In my perspective, the Federalist Society has been a wonderful place to get together with the many, many lawyers who are members and learn about the law and discuss issues. Aside from my own experience, as a judicial nominee, I don't think it's appropriate for me to comment on any public policy debate about the Federalist Society or the particular quotation you're referencing.
Do you know
Smart
Leonard Leo?
lady.
I've met him a few times at Federalist Society events, but I wouldn't say that I know him well or that he knows me.
Do you concur with the president's assessment that he's a sleazebag?
Again, Senator, that type of interpersonal or political dispute I don't think is appropriate for me to comment on as a judicial nominee, given that either the president or Mr. Leo could come before me as party to a litigation.
You clerked for Judge Richard Leon, did you not, on the district court?
That is correct.
How would you describe Judge Leon?
When I worked for Judge Leon, I had a wonderful experience. I think he was a judge who treated everybody with fairness and impartiality and was wonderful to his law clerks. And it was a very enjoyable year clerking for him.
And he took his responsibility seriously
In my experience, yes.
and upheld the law and the Constitution, in your view?
We did our best to do so.
You're aware that he ruled against the administration and against the president with respect to the president's executive order against Wilmer Hale?
I am aware.
Do you agree with Judge Leon's decision that the executive order was unlawful?
That's pending litigation, and it would be very inappropriate for me to express a view on the merits of that litigation or any other active litigation.
Well, no, the president has attacked the Federalist Society because the judges it has recommended don't always do what the president wants. Is that the role of a judge? Is that the role of Judge Leon?
You know, of course, presidents are going to be angry when they don't get rulings they like. And, you know, shiftless, you're confusing me here, okay? You're bastardizing judges who rule, you know, you've bastardized judges who ruled for Trump, claiming that if they ruled for Trump, that they're sycophants. Yet, you're wanting to know if those who rule against him are sleazebags. You're wanting judges now, you know, as your previous man there said, you know, difference of opinions. And judges rule as they think is right, but, you know, not all judges are always right. That's why we've got appeals courts, and that's why we've got the Supreme Court to actually determine what is law, what is constitutional. And appeals courts don't always get it right. I mean, look at the Ninth Circuit. My God, for years, 90% of their rulings were overturned by the Supreme Court. So you're going to say that, you know, the Ninth Circuit was sycophants to Democratic judges? Are you going to say that when your side goes shopping for judges to make rulings that you like? Because, that's been, admitted to, that y'all file cases in courts where you're going to get a judge who's going to rule the way you want him to rule, or the way the Democratic Party wants him to rule.
Or any other judge, would that be your role to do what the president wants?
That would not be my role. My role would be to carry out my oath, which would be to the Constitution first and foremost, and any other laws that bind the rules of decision.
So you're willing to rule against the administration, against Donald Trump's executive orders if you believe them to be unlawful?
If that's what the law requires, Senator.
You are also an attorney at Williams and Connolly, is that correct?
That's correct.
And they represent Perkins Coie in the executive order case against that law firm, do they not?
I'm aware of that fact.
Is it important that law firms be able to represent individuals or causes that are unpopular and that are at times in disagreement with the administration?
So certainly, as a lawyer who represents a client that has views that people don't always agree with, I think it's an important role of an attorney to take on matters no matter the political popularity.
So you think it's appropriate for law firms to take on cases against the administration?
I would not purport to limit any party in the representation that it would choose. And I don't want to be seen as commenting on any of the active litigation involving these issues.
And would you agree that it would be inappropriate for a president or administration to try to punish a law firm for taking on a client whose interest was adverse to the administration?
So, Senator, you're referencing, I believe, the pending litigation. And again, I've articulated why it's important for clients to have law firms.
I'm not referencing any particular case. I'm asking you as a general principle. Should the president of the
you're
United States
lying,
be able to
Saka.
retaliate against the law firm
You wouldn't
that
be
takes
asking
a
that
case for a
question if it
client
wasn't up
whose
there right
interest is
now.
adverse to the administration?
Again, embedded in the premise of that question is something that is referencing active litigation. And I just, as a matter of prudence, don't want to be seen as weighing in either way on whether that has occurred in any of these executive order cases. I stand by my answer that it is, of course, the role of a lawyer to represent clients consistent with the bounds of the law and ethics. And that's what I've tried to do in my role.
Thank you, Mr. Chairman. I yield back.
Professor, tell me about the Loper-Bright case.
Okay, I've got.
Hey, this is Senator John
I know
Ossoff
I
in
don't
Georgia.
do Republicans. I skipped over
Can you chip in
Ted Cruz,
$5?
but I will not skip over.
Sure. So
my
Loper-Bright
favorite,
is the
over
case that
Kennedy here.
overruled the Chevron doctrine. And the Chevron doctrine originally required that if there is an agency statute that governs an agency's conduct, the agency gets deference, meaning a thumb on the scale, when it's interpreting what that statute might mean as it's carrying out its duties. Loper-Bright determined that that framework was inconsistent with the Administrative Procedures Act, and instead that moving forward, courts should decide all of those statutory interpretation cases as a de novo matter, meaning the agency doesn't get any sort of special head start.
How much deference did a federal court have to give to an administrative agency under the Chevron doctrine?
Sure. So the court would originally make a step one determination about whether the statute was ambiguous or not. That's in the eye of the beholder sometimes. But if the court determined that the statute was ambiguous in the relevant sense, meaning it didn't resolve the question the agency was facing, it would defer to the agency's view of the meaning so long as the agency's interpretation was well explained and reasonable.
What's the relationship, if any, between Loper-Bright and West Virginia v. EPA?
So that's a fascinating question. I think, West Virginia versus EPA applied Chevron, but said we're less likely to find ambiguity. And indeed, Congress needs to speak clearly if the agency is purporting to resolve a matter of, in the court's terms, political or social significance.
Well, this is why I love Kennedy.
Following Loper-Bright, of course, there is no
asking
deference.
questions
And I think
about
some have
law.
commented, including Justice Barrett, that the best way to think about West Virginia versus EPA in interpreting statutes is that it informs the context of how we understand what the statutory terms mean in the context of an agency delegation. So the fact that the agency is purporting to carry out its duties might resolve whether or not the particular question is sufficiently clearly delegated by Congress.
That just seems to me like a distinction without a difference. I mean, doesn't Loper Bright wipe out the need for West Virginia v. EPA? Why do we still need a major questions doctrine?
So it's certainly true that West Virginia versus EPA, I think, was partially driven by non-delegation doctrine concerns and concerns about deferring to agencies when doing so threatened our separation of powers. After Chevron has been overruled, of course, that might be relevant in a smaller number of cases. But I do think that the major questions doctrine still has vitality in understanding the best meaning of the statute as Loper Bright now requires.
What's the public rights doctrine?
So most recently, the public rights doctrine has been applied in the Seventh Amendment context, and the Supreme Court has a decision named Jarkissi, where there's a line of precedent saying that if a matter involves public rights, so the conferral of a public benefit, for example, that might be the type of matter that Congress can vest adjudication of in Article I tribunal or in an administrative agency.
What's a public right?
That's a very difficult question to answer in many cases.
That's why I'm asking you.
Yeah, so I think the best way to think about it is to contrast it with private rights. And what the Supreme Court has instructed with respect to private rights is that they're what we would think of as common law type claims. So contracts, property, torts, the stuff of Westminster in the court's terms. And so if you have a matter like that, that's the type of matter that needs to go before a jury to ensure that the Seventh Amendment's jury protections are abided. By contrast, if there's an internal administrative process, Social Security benefits, things like that, that looks more like a public right that wouldn't have existed but for the government granting it.
And what did the Supreme Court hold?
Well, see, Kennedy, these are the kinds of questions Kennedy asks regardless of who's on the other side. Now, sometimes though, he'll say, okay, what's Article 3 of the Constitution? What's Article 2 of the Constitution? But Kennedy asks about specific things that the jurist should know. And he holds no favor as to party. And it's absolutely wonderful to see this man's mind at work when he's asking questions, because he'll vote against you if he doesn't think that you're fit, because you can't answer questions like this as a jurist. And he doesn't care who nominated you.
Oh, in, was it Jarkissi?
That's right.
What did the Supreme Court hold?
So the Supreme Court there held that certain matters of the Securities and Exchange Commission actually looked more like common law fraud claims and more like property-based claims that must be tried to a jury in court and cannot be vested in the in-house SEC proceedings to be tried before an administrative tribunal.
My time is done. Thank you, Professor.
Okay, against my better judgment, Senator Schiff, I promised Senator Schiff, because I skipped him in order. I promised him one more question. All right, Senator. This gavel will never come to me again, though, if you ask more than one question. So I'll hold you to it.
I've got
Just in honor of Mike Lee's birthday. His wish was that I get an extra question. I wanted to just follow up on one of your answers to Senator Durbin. He asked about the necessity of following court orders, and you were very specific in your answer and said that if the Supreme Court rules,
chill any room in 90 seconds with this NASA-inspired breakthrough. It's smaller than a toaster, cools.
that you have to follow the order as it pertains to the parties to the case. I want to ask you about a lower court ruling, though. You would agree, would you not, that if a district court rules pending appeal or pending any other stay or action by a higher court, that the parties covered by that order, including the administration, need to abide by that order.
As I mentioned to Ranking Member Durbin, the normal course, if you disagree with a court order, is to seek appellate review in the way that you mentioned. Yes. I do note that my understanding is yesterday there was some testimony about, particular cases and nuances of that debate that I think are active. And obviously the interaction of Article 3 and Article 2 is an actively litigated matter. But absolutely in the normal course, the proper way to vindicate your rights is through the appellate process.
Thank you. All right. Thank you, Senator. No, really, John?
Yeah, I do.
Oh my gosh, let's look at this. All order is dissolving. Okay, go ahead. But that's it. I'm serious. Senator Grassley's going to come in here and hit me with this
I
gavel.
want to be sure I understand, Professor. District court rules in a case. You got plaintiff or defendant and defendant. You're representing the plaintiff. Your plaintiff is very unhappy. Are there any circumstances under which you would advise the plaintiff to ignore the federal court order?
So of course, as a judicial nominee, I would be trying to
I
issue
don't want to
proper
split
orders.
hairs here.
No, the normal process is to
I know what the
seek
normal
appellate
process
review.
is. Can you
Right.
think of any circumstances where you would tell the plaintiff, nope, you don't pay attention to this federal judge?
So the problem with answering it that categorically is that there are potentially some very extraordinary situations you could imagine
Like
that
what?
could come before me as a
Like
judge.
what?
So this is a subject of tremendous
careful there.
scholarship.
I'd be real careful.
All
there,
right,
Professor.
Senator. All right. I promised you one. That was 4, I think.
Okay.
See what you started, Adam.
Okay.
Ms. Hermendorfer, thank you for your testimony. You are excused.
And that is the end of that of her. And see, she's may have lost Kennedy's vote. She may have lost Kennedy's vote here, and because of the way she answered Shift for Brains. So I just saw the post you deleted there, Raman. It's not that I've got anything against Ted Cruz. It's just I don't find a lot of his questioning of nominees that are by the president of the same party he is. I don't find his questioning as in depth as I do Kennedy's and Marsha Blackburn's rather. All right. Not Kennedy doesn't care. He just wants to make sure they got a good judge on the bench. And he doesn't care where you come from or who nominated you. Marsha Blackburn is very similar to that, though she does, though she is a little softer in a way than on a Republican nominee than she is on a Democrat nominee. And yeah, he does. So that's why I always want to listen to Kennedy's questions, because he will root out an ignorant. And when I use ignorant as a judge who is unknowing, especially on the finer details. And I can see him and her having a private conversation, Kennedy and this woman. Well, she's already been voted on and she passed the vote. She is now a federal judge. But I could see that they had a private conversation later on about this point, that he called her up and had her come to his office. So that's that. Okay. Um, and I think I am going to end it there. I think I'm going to end it there for the day. Um, then tomorrow, of course, is Fun Stream Ramen. And let me shoot you a quick invite here so that if you want to talk, there we go, talk off stream, we can do that. Did I shoot you? I think I already shot you an invite, didn't I? Well, just in case, because every now and again I'll post something in X or shoot off an invite in X or say something in DM and it won't go through. I thought I had X open. Well, let me open it again. What's her name? Come on, open up messages. And paste. There we go. Oh, Lord have mercy. Tomorrowland stage burns to the ground. Wow. So anyway, ladies and gents, that is the end of the stream. Raman, go ahead and check, see if you got the invite so I can pull you up before I end the stream and then you can't get on. Because I think it went through this time. Yeah, it looks like it actually went through. Oh, and just if anybody is still concerned, I know I wasn't, but it's on that made the headlines. Michael and Barry Obama did not get divorced or are not getting divorced. So no name or avatar, huh? But that's the end of the stream, ladies and gents. And I've got bread to bake because we are going to attempt to have the wife's friends back over again on Friday night. So I'm going to bake the bread today. And tomorrow I'll make the pasta and put it in the refrigerator overnight. And then go from there. And other than that, everybody try to have a good day. Try to enjoy yourselves. Be with the ones you love and love the ones that you're with. Have fun. Raman, where are you?
Hello.